If there's an independent judiciary, then you can uphold the rule of law in a democracy.
Yes.
What steps have been taken in Sri Lanka to ensure that the judiciary is independent?
The judiciary has expressed their views independently and fearlessly on most of the occasions. Before you talk about a new constitution, Alanki, I think we should need a new political system. We have failed in our obligations towards people. We need a new political culture, a correct attitude change in the mindset of the people and the rulers both. Then you think of the constitution. Have we been successful in our parliamentary system, or is our parliamentary system a failure? I think that our parliamentary system is a failure.
I do believe this was a very insightful conversation for all of you who watched it, and there's so much you could have learned about the law and about the legal system of Sri Lanka. Welcome everyone, you're watching Conversations with Alanki. What is the law? The law can be defined in various ways, but one thing is for certain. The law ought to protect and uphold the rights and liberties of citizens. Today I will be in conversation with Kalinga Indatissa, President's Counsel and the former President of the Bar Association of Sri Lanka. Welcome to the conversation. To start things off, tell us, how long have you been in the legal profession?
Well, I was enrolled and admitted as an attorney at the Supreme Court of Sri Lanka in 1986. So I'll be completing 35 years in the month of May this year. What prompted me to do law was a book which I read when I was about 8 years old. A book authored in Sinhala by Mr. W.A. De Silva called Hingana Kolla, which later on became a movie directed by Mr. K.W. Pereira. In that particular book, there is a character of a judge of the Supreme Court called Sir Henry Vijayakon. So the trauma that he went through when he had to deal with his own son without knowing that he was his son is what really took me a liking or developed a liking to the law. So I started my law college in 1982 at the age of, I was 17 years when I joined law college.
At a very young age.
Yes, and I enjoy it. I've been enjoying it for the last 35 years.
You were the president of the Bar Association of Sri Lanka.
Yes.
What were your most significant contributions when you were the president of the Bar Association of Sri Lanka?
Well, at the time that I took over as the president of the Bar Association of Sri Lanka in 2019, there were certain issues facing the entire bar as a profession. One of the things that I had to clear during the last 2 years was that I had to make sure that the bar does not become political. Secondly, we introduced several programs for the membership, especially for the young members. We managed to introduce advanced technology to the branches. In view of that fact, today, at least 40% of the branches are equipped and they can connect up online, and most facilities are provided. Then there were three other issues that I would like to comment very briefly. 2019-20 was a period that there were several appointments which were being made as President's Counsel. Now, President's Counsel is a privilege that is accorded from the British period, coming down from England, to people who have reached eminence in the legal profession. But Sri Lanka, being a lot of things being dictated upon politics for the last 3 decades, certain appointments were questionable by the bar. So in view of that, during President Sirisena's time, when a large number of appointments were made, we managed to go to court and get a ruling identifying the criteria upon which people should be considered for appointment as President's Counsel. That was a major victory for the bar.
Absolutely.
Then the other thing is, even with regards to the judicial appointments to the higher courts, the Court of Appeal and the Supreme Court, certain expressions were made by the Bar Association. The view of the Bar Association was considered by the executive. So we are fortunate in that situation. And also furthermore, you would remember the MCC. When the cabinet meeting was going on to pass the MCC, I was informed, we managed to protest, not in a very, very peaceful way, by addressing the issue to the President and the Prime Minister at that time, which actually stopped the MCC being signed on that day. We did not take a different stance. At that time, the President was His Excellency Maithripala Sirisena. Then after His Excellency President Gotabaya Rajapaksa became the President, we continued on the same lines. For the bar, as to who is in authority or power does not mean. We never changed our stand. We made the same representations and objected to certain areas of the MCC, and as a result of which I believe it did not see the light of the day. So those are some of the things that I can speak of during my 2 years.
Those are in fact valuable contributions towards the legal system, I believe, and you did mention that it is very important that the bar is independent. And in the same way, it's very important that there's an independent judiciary. Because if there's an independent judiciary, then you can uphold the rule of law in a democracy.
Yes.
What steps have been taken in Sri Lanka to ensure that the judiciary is independent?
In answer to your question, I must confess that there are certain statements which have been made by certain individuals at certain points of time relating to certain decisions of the judiciary of this country. Now, that never started yesterday, day before, or 2-3 days ago. That situation of, making comments upon the judiciary has been there for some time. But by and large, I must say, as a person who has practiced law for the last 35 years, judicial independence and independence of the judiciary as an institution is an extremely important and a vital factor to maintain rule of law. If the judiciary is corrupt, if the judiciary is not up to the standards, then there is a problem within every legal system. But I must say, I have gone through this process for the last 35 years. There could be situations where people could make comments. But at the same time, by and large, the judiciary has expressed their views independently and fearlessly on most of the occasions, or majority of the occasions. Now, one of the things which concerns the bar is the method of appointing of judges. There was a time when the appointments came from Her Majesty the Queen. Then after we became a republic, it was the Governor General and the state. When we started the executive presidency in 1978, it was the president to the higher courts. Now, all these systems, I cannot call them as foolproof systems. Now, there is a lot of issue in this country about these independent commissions being removed. Now, in my view, independent commissions is a very good thing conceptually. As long as you can find independent people to serve in these commissions. My feeling is sometimes some of the appointments which are made by the so-called independent commissions did not protect the judicial independence or the independence of the judiciary. There were people who were bypassed. So what we need is all the people, stakeholders must come together, identify a proper mechanism regarding the recruitment and appointment to the Court of Appeal and the Supreme Court and the other courts, and that has to be laid down. So as far as I am concerned, what I see is some of these commissions, I cannot subscribe to the view that they actually did what they were supposed to do, what they were intended to do. You have to sit back, that is where all stakeholders, when I say the Attorney General's Department, the judicial officers, the retired judicial officers, and the private bar. All of them should come together and find out a mechanism. What is the system on which a judge is assessed? It must be an internal system. It can't be put out to the public. How is the judicial independence of a judge assessed? How is his efficiency assessed? How is his work capacity assessed? So without such a mechanism, whether it's an independent commission or appointments by the executive, will not serve any purpose.
So what you're implying is that in order to ensure an independent judiciary, all stakeholders must be independent.
They must be consulted to identify the mechanism. Right? Sometimes some of these things are political decisions. Okay, the bar is never consulted. The bar ought to be consulted because the members of the bar are the people who face the judges every day. They know the problems which are inherent within the system. So they should also be consulted in formulating the mechanism of recruitment, appointment, and promotion of judges.
Furthermore, this brings me to the next question. The separation of powers, as you know, is a concept which means that power should not be concentrated in one body alone.
Yes.
Do you feel that the 20th Amendment to the Constitution obstructs the separation of powers?
Yes and no. Yes and no would be the answer to your question, because the concept of separation of powers actually started in France. The person who was responsible for introduction of that concept is Montesquieu. Now, what does it mean? Power corrupts, absolute power corrupts absolutely. You have the three pillars: the executive, the legislature, and the judiciary. You can have them independent and functioning separately, but at the same time, you must remember, for a democracy to run, there must be some leverage.
A certain overlap.
Certain, not overlap. There must be some situation where they could act together, consultate. That is not a disrespect to anybody's powers. So in that context, now when we say 20th Amendment, now I have a question. Now I have no interest in politics. I have heard that a new constitution is coming.
Yes.
If a new constitution is coming, what was the need to come with the 20th Amendment is a question that I have, which remains unanswered. On the other hand, we all, 20th Amendment takes away certain things. The independent commissions, so-called independent commissions, all those things were taken away. But the question that I have is, there is some degree of taking away certain norms of the concept of separation of powers, but at the same time, I was never involved, or we were never consulted, or I was not privileged to be involved in the constitution making when the 20th Amendment was passed. But I believe, according to what the draftsmen of the 20th Amendment say, that they found that this commission system is not working properly. I don't know whether it's a political decision or it's an actual decision, I would know. But there again, a constitution has to be for the people. So views of people should be obtained prior to any amendment or serious amendment which may have drastic consequences are implemented. So I see that that's why I said yes and no, because some areas of the law, of the amendment, cuts across certain aspects of separation of powers, where some areas are retained as it were prior to the amendment.
Do you feel that we need a new constitution? And if so, which aspects of the current constitution needs to be changed?
Before you talk about a new constitution, Alanki, I think we should need a new political system. We, in my assessment, without any comment on any individual or a political party, we have failed in our obligations towards people. Why do I say we have failed? When we were small children, I remember going and visiting the parliament, where we could learn a lot. Now look at the situation in the parliament. Dignity, decorum. I don't have to say it. The people who watch the proceedings will know whether it has gone down or it is going up. We need a new political culture, a correct attitude change in the mindset of the people and the rulers both. Then you think of the constitution. Now, 1972 constitution was hurriedly drafted because we wanted to become a republic. Until such time, we had the sole-body constitution in force. Then 1978 was drafted, which was a mixture of constitutions of few countries, by President Jayajayawardena, His Excellency Jayajayawardena, introducing the executive presidency. Now, introducing the executive presidency, he considered so many other factors, and he knew that once the constitution comes through, he will be there until he decides to step down. Then he gave himself 2 terms. Now, there were issues where the 2 terms were relaxed. So, all what I say is this. Constitution again would be for better governance. No? So when you have a system of better governance, when you're talking about better governance, if you draft any constitution with extraneous intentions or outside intentions, that is not going to work. It will crash maybe 10 years, 15 years, or at some point of time. So, there again, how do we make this constitution? All political parties will have to be consulted. Now, when you say they are against Sri Lanka, if you have 5 people and call yourself a political party, you are registered as a political party, then their views also have to be considered. I believe that is one of the concepts of democracy. But my thinking is there has to be a broader consensus, broader discussion with people, right? Stakeholders, people, civil society, different segments of certain professions, in order to bring a new constitution. Otherwise, no new constitution will serve the country.
Unless you have a new system in place.
A new system, I don't think anywhere in the horizon I can see any new system coming up, because we are so much based on power. No? There is so much now. Why did the British have to now in England you have the House of Lords and the House of Commons, right? When you look at the concept of House of Lords and House of Commons, one may think that is discriminatory. Commons are from the common people, but the system ran. So we also have to have a system now. I mean, a lot of people who should be involved in governance, I won't use the word politics, governance will not get involved for the simple reason they will not be heard. So have we been successful in our parliamentary system, or is our parliamentary system a failure? I think that our parliamentary system is a failure. But I would say that all as I said, have a dialogue, get all the parties involved, get all stakeholders involved, identify what is best for the nation. That's all.
All right. The next question is something that is of concern to many. Many are reluctant to go to courts to seek a remedy or to settle a dispute because of the law's delays. Why is this the case?
When I was called to the bar 35 years ago, law's delays was an issue that we spoke of. And after 35 years, you are asking me the same question. One of the biggest problems that we have, we have a unique legal system, Alanki. We had our own ancient laws until 1505, coming down from the Sinhala kings, that period. Then 1505, the Portuguese came. 1656, the Dutch came. 1656 to 1796, the Dutch ruled the coastal areas. They introduced the Roman Dutch law concepts. Then the British came. Now we have a system. Initially, if you take our legal system, we were a mixed system. There were segments of Roman Dutch law, native law, ancient Sinhalese law, Tesavalame, Mukwa law, and the Muslim law. All these things were in a mix. So we are what I call a mixed legal system. In a mixed legal system, sometimes, again, you have to sit down and identify how appropriate the mixed legal system could be run in the context of today. Because now, from the last 50 years, concept of rights have developed. Now, everybody starts talking about rights. That's another issue that I would like to comment. In Sri Lanka, everybody has a right. Nobody talks about duties, right? So everything is a right. I have a right to go to school. If a teacher assaults you, I have a right to complain. Likewise, nobody talks about your civic duties anymore. We were brought up within a system where we were taught about duties. We had a subject called civics at that time, which later on became social studies, right? So what I say is, why are we having these delays? Sri Lanka is not the only country which has lost delays. In a system where there is an element of these mixed concepts going, you take India. In India, they say it's a curse to go to court, because if you go to a court in India, it takes you 15 years to come out of the first court. Then there are 2 appeals. So one of the things I can in a nutshell tell you, we have to have a relook at all the legislation that we have. The current Honorable Minister of Justice is on it. He has been practically on that from the time he assumed duties. He is one gentleman who has consulted the bar always. He was a former deputy president of the Bar Association, and he was an active member of the legal profession until he assumed duties as minister. So therefore, he has that passion of doing something. Secondly, we must identify more simplified procedures. Now, in our country, there are two main codes, the Criminal Procedure Code and the Civil Procedure Code. You know, these are very cumbersome procedures which was introduced long time ago when the litigation was not that much. Now, in view of the increasing number of lawsuits, in view of the people's rights concept being enhanced, we have to sit back. Number one is we have to look at the litigation, legislation. Number two, we must introduce more and more simplified procedures where people can access court and come out of it. Otherwise, it's a curse. It's a curse. That is what I believe. Laws are for the people.
Do you think we'll see a change anytime soon?
It's very interesting. You asked me that question only 2 days ago. The Honorable Minister, at his request, we are trying to establish what is called a family court. Family court is where divorces can be obtained, judicial separations could be obtained, where children's custody matters should be discussed and finalized. So if that family court comes, a large segment of the district court work or civil court work will go there. And if that family court can introduce more and more simplified procedures, that court is going to take the burden of the other courts. And as a result, the other courts will have more time to work. So there could not be any delays in litigation.
All right. If there's one thing you could change about the legal system in Sri Lanka, what would it be?
If there is one thing that I could change about the legal system in Sri Lanka, it's an extremely difficult question. You have put me in a fix, but there's one thing I want to do. I always believe that laws are for the people. Laws are not for lawyers. Laws are not for others in the legal profession. So if you take it in the context of laws being for the people, I believe we will have to identify and introduce very simple laws, A, and parallelly, simultaneously, I believe that the criminal justice mechanism or the criminal justice system cannot take time. Unnecessarily, the criminal courts are burdened, and if you become an accused, and for a wrong reason, somebody, if the officer in charge of a police station does not like my face, he can land me in a criminal suit, and I will not get out of it for the next 10, 15 years. So there must be a procedure that has to be introduced where litigation is periodically assessed. Otherwise, what happens is today a case is called, it will be postponed for another 6 months. There is no proper assessment of that case. Why was it postponed? Why could not it be terminated? What is the reason? Who is behind this? All these things there is no supervisionary system. That is what I will do.
And moving on to the final question, what has your long journey in the legal system taught you? If there's one thing you could talk about.
You know, one of the things which I have enjoyed, I'm a writer. I have written now 57 books on law.
Okay.
Except for the 2 years I held office as president of the Bar Association and a few other years, I continuously taught at law college. So one of the biggest things, if you ask me, one of the biggest achievements in my life, I would say, would be the generations of students whom I have taught. Some of them are now in the Supreme Court as judges. So when I see them, I feel happy. But at the same time, I must tell you, the legal education system also has to change, Alanki, because we are still not turning our young men and women to be 100% professionals, as it ought to be. Now in England, you have the insert court. The product which comes out from the inner court is a professional. They are taught to think professionally, they are taught to conduct themselves professionally, they are taught to talk professionally, hold yourself out in a crowd professionally. But that doesn't happen in our legal system. It's a matter of, by hearting something. So the whole legal education system, in my view, has to change. So that is one of the proudest things I've done. If I look back over the years, the proudest achievement in my life is teaching law.
That must be very fulfilling.
Of course, very, very, very fulfilling. Yes.
We have come to the end of this conversation. Thank you so much, Mr. Indatissa. I do believe this was a very insightful conversation for all of you who watched it, and there's so much you could have learned about the law and about the legal system of Sri Lanka. Thank you for watching. I will be back with another episode next week. Until then, take care and stay safe.